Hey kids, welcome to this brand new video lecture looking at major Supreme Court cases. Moving on today largely to what was known as the Warren Court. Earl Warren became a Supreme Court Justice in the 1950s and I believe Chief Justice around 1953 or so. Very often, by the way, Supreme Courts are referred to as the blank court based on the name of this Chief Justice. This Chief Justice gets one vote like everyone else, but he's sort of the lead justice among equals. In other words, he does the assigning of who writes up the opinions, will set some guidelines, and is probably considered to be the most influential. Incidentally, anybody have any idea what today's court is called? It is the Roberts Court. Chief Justice John Roberts, appointed, I believe, by George W. Bush, is the fairly conservative Chief Justice right now. Remind you that you've all got this chart, and yes, you can print it and take notes by hand, or you can type in, fill in the boxes, etc., etc. Either one is fine, and I won't ask you to send this in until we finished all of these. So get through all 5 of the video lectures from this section. Remember that there may be a couple of court cases that I mention, but that if it's not here on the chart, you won't be responsible for it. And remember also, you should be sending in either handwritten or typed up video notes for the first lecture in the whole series, which just kind of set out guidelines for how the court system works in the Supreme Court and so forth. I got about a dozen for you today, but I think they'll go a little bit quicker than the last time. There are a lot of similarities, as you'll see, in between these cases. The Warren Court in particular, we have already covered Brown v. the Topeka Board of Education. This is pretty important because the Warren Court was seen as being a judicially activist court. In other words, they apparently seem to see themselves as the court taking a major role in making major changes in the country. Well, let's take a look at racial discrimination. Yeah, well, what are you going to do? The Constitution says what the Constitution says, but it's not the court's job to do anything about that. Well, Earl Warren fundamentally changed that. He said, you know what? We are not following the Constitution. The state governments aren't enforcing the Constitution. The U.S. government is simply standing back and twiddling their fingers. You know what? We as the court are going to assert ourselves, and we're going to be a real avenue for change in this country. Again, controversial. Some see the court's job as being far more passive than that. But nonetheless, that is the approach that the Warren Court took. And that really carries over into about the mid-70s or so. Earl Warren does die. He's replaced with another Chief Justice named Warren Burger, his name was. You don't need to know that, of course. But they continued to be more on the activist and more on the probably pro-individual rights, more liberal courts, I suppose you might say. So we'll take a look at about a dozen of these today. First of all, Mapp v. Ohio, one of our naughtier cases. There is a woman whose name is Dolly Mapp, and the Cleveland police entered her home without a warrant. Ding, 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 ding. And what did they find? Obscene materials. I've never known what sort of materials these were. If it was obscene writings, photographs, etc. Well, that was considered illegal in the state of Ohio. She was convicted based on the evidence. So the litigant, the person bringing the case, she's found guilty. She exhausts these appellate court options within Ohio. Eventually, the case makes it to the Supreme Court. What do you think would be the constitutional provision that she's arguing was violated? It is one of the Bill of Rights amendments. Can evidence obtained through illegal search be used in a trial? And I do believe that is the Fourth Amendment. Check that. I get my 4, 5, and 6 confused sometimes. But the Fourth Amendment, you can't use illegal, and you can't simply enter someone's house and look around. So she's arguing, hey, this may or may not have been my materials. They may or may not have been legal, but the proper procedure was not followed. The police had no business in my home. They entered my home. Therefore, my conviction should be overturned. The court rules that this is true. Yes, Fourth Amendment. It's called the exclusionary rule. Any evidence that is gathered in any way that is not considered to be constitutional must be thrown out. And this could even include, like another example might be, if I've confessed to a murder, and maybe I did it. Maybe I did kill 7 students from last year. Have you noticed you haven't seen any seniors from last year around campus? Huh? 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 All right. Maybe I did kill them, and maybe I confessed to them. However, if the evidence for this was done through, let's say, using torture on me or taking away basic rights, though that evidence, that confession would be excluded. So Dalry Mapp's conviction is overturned. And then from this point, because these all set precedents, later court cases and police departments and state entities had to be much more careful about getting the warrants from the judicial system that they need to be able to enter someone's home. You're going to see, by the way, a twist on this when we get to the O'Reilly v. California during your lifetime. Engel v. Vitale, and this is one that I think people in Santa Cruz, Bolivia would simply have a hard time getting. This is a fairly religious country. Santa Cruz, from my understanding, is very, very religious. I don't have too many students who've said they don't consider themselves to be religious. There are certainly some. There are probably even many, but it's pretty much the idea of separating religion from the rest of your life is just something that doesn't come up here as much as it does, certainly in Europe and to a degree in the United States. Parents in a high school, Hyde Park, New Jersey. Notice it is a public school, and that's important because private schools can do what they wish to do in regards to this. Every day they started off the school day with a prayer that includes an almighty God. The parents weren't that comfortable with this. It's actually Stephen Engel, who is the father, because he has standing to sue because his child is affected and the child is a minor. What do you think the constitutional issue here was? The Establishment Clause of the First Amendment. Now, we know that the national government is not supposed to establish a religion. But now, as of 1868, 14th Amendment incorporated the Bill of Rights and applied it to the states. Mr. Engel and his family are arguing that by the fact that a public school is having the students stand up and pray to an almighty God is forcing religious belief. It's prioritizing a certain religious belief over others. Therefore, these should not be happening. The courts rule 6-1. Government written prayers cannot be recited in public schools. And that stands for the most part today. Now, it can get trickier. What about other religious symbols? Having a school Christmas party, it's often called a holiday party. And again, myself, I can see that I do not want my child to have, hi, we're standing and praying, we're reciting this, we're reciting that, regardless of the religion. At the same time, I would have personally less of a problem with like, oh, a Christmas party or a Christmas tree. To me, that's more cultural than it is a direct religious belief, etc. But yeah, no, an interesting question to be sure. At what point is government imposing beliefs, and at what point is it simply reflecting the culture around them? But this seems to be true to this day. Has been largely upheld, although it's constantly being challenged. By the way, if you talk about evangelical Christians in the United States, generally tend to be Republicans, tend to be very politically conservative. One of the things they've discussed is we need a constitutional amendment that guarantees you the right to openly pray in school. Now, mind you, in an American public school, if 6 students wanted to start a young Muslim or young Christian club, and in their off time or over lunch, they could request, like any other group, a club. However, it can't be a whole class thing sponsored by the school. 1963, a fairly big one, Gideon v. Wainwright. Clarence Gideon, remember, the first name is the person bringing the suit to the Supreme Court. He was a criminal who had been unable to afford an attorney, and the state of Florida said, we're not appointing one. I believe it was armed robbery or burglary of some sort. Mr. Gideon was, basically a career criminal. He had a very, very rough upbringing, very limited education, was a troubled guy to be sure. But the point was, of course, that in the Constitution, it guarantees you the right to an attorney to defend you. Well, here's a question. You have a right to one, but do you have must government provide an attorney for you if you can't afford one? That's a different question. Hey, you can go out and hire the most expensive lawyer in the United States. If you don't have the money, that's your problem. So Clarence Gideon is the litigant. What part of the Constitution? This is a Sixth Amendment case, Fifth and Sixth Amendment both, due process and the idea of having an attorney. Remember, this applies initially to the national government, but the 14th Amendment takes the Bill of Rights and applies it to each state. Landmark case. Court rules, again, the Warren Court, unanimously. Gideon has a right to a lawyer. And again, this sets a precedent. The way the opinion was written, it didn't say, well, in this one particular case, Clarence Gideon should get a lawyer. It said, anybody who is indigent, anybody who is poor, who is accused of a felony and cannot afford an attorney, shall have one provided by the state. And in fact, if you think back to those police movies you've seen, you have the right to remain silent. Anything you can say will be used against you in court of law. You have a right to an attorney. If you cannot afford one, one will be provided. Boom. Those are the Miranda rights that include the outcome from the Clarence Gideon situation. Now, this sounds good, and I don't think many people disagree with the idea behind this. Of course, it does not suggest equal justice. And here's a reason. I want you to think that any one of you, myself included, we are accused of a serious crime. And maybe we did it, maybe we didn't do it. What kind of a lawyer do we hire? Do we get a public appointed lawyer? Well, almost certainly with the resources we have. We have either our own bank accounts or our parents or family or friends with a lot of resources, and you get yourself the best possible legal representation you can. Now, I will tell you that a lot of court-appointed attorneys that work for the city, that work for the state, some of these are, just the salt of the earth. I mean, these people that give their lives to protecting the most desperate people, but it is not uncommon for a single court-appointed attorney to have as many as 200 to 300 active cases. Now let's think about this. How much time would that person possibly have to work with an individual client? Other problem too is that, look, let's be honest, not every public attorney, public defendant is necessarily a terrific lawyer doing it out of principles. Sometimes, and there's some good evidence of this, people that have just been failures, not very good, not very conscientious, I need a job, oh good, the state is hiring. There was a terrible case in Texas a few years ago. I think the man's last name was Davis. He was accused of murder. I don't have any idea about how strong the evidence was. His court-appointed attorney missed a number of days of the trial, and when he did show up on more than one occasion, he fell asleep during the trial. He was found guilty. Mr. Davis was sentenced to the death penalty, sentenced to be executed. Now, he filed a suit that said, look, this court-appointed attorney was missing the trials and then falling asleep. I didn't have competent defense. And the Texas Supreme Court voted 2-1. This was his final appeal. Look, the Constitution guarantees you the right to an attorney. We never said you're guaranteed a competent, responsible, or awake attorney. Needless to say, if Mr. Davis had come from a wealthier family, he would have had better representation. He was executed shortly after that. Texas loves to execute people. It's one of the things that Texans are the proudest of. And one of the reasons why I'm not a very proud Texan, but that's my own personal view. Next case you certainly are familiar with, and we've actually heard a little reference to it in the Gideon v. Wainwright case. I'm wrong. That's the one after that. This actually is less exciting to you, but pretty interesting. The New York Times, of course, a major, probably the major newspaper in the United States. And Sullivan was, I believe, in Mississippi or Alabama. I can't recall which, but he was either the chief police or constable or something like this. Well, the New York Times had published an advertisement that was paid for supporting Martin Luther King, and it contained some information about Mr. Sullivan that turned out was not true. So the New York Times was being sued for libel. Um, Libel basically means you've printed something that is false and damaging. Slander is speaking something false and damaging. They were found guilty initially. I believe this would be in New York State. And so the New York Times publisher, whose name was Arthur Oakes Sulzenberger, it's passed through the family, he filed the suit arguing that, look, the information was incorrect, but we believed it was correct at the time that we published it. So here's the question. This is First Amendment. Now, there is no question that if the New York Times makes something up, flat out lies about something, trying to destroy a career, and they're aware of it, there's no question that that is libel, and that can be a pretty serious offense. However, since they believed, to the best of their judgment, that all the information contained in something they published was in fact accurate, should this still lead to a conviction for libel? Or if every time a newspaper, a TV station started to publish something controversial, if they stopped and said, wait a minute, what if there's a small chance that this is inaccurate? What if there's some kind of a mistake in what we think to be true, but it's not? Is someone going to jail? Are we being sued for millions? And you can see if that was a concern, that's going to put a major, major damper on what any newspaper or TV station or other media source will be allowed to or feel comfortable trying to produce. Again, Warren Court unanimously. News sources cannot be sued for libel by public figures, and again, here's the language, unless actual malice. Malice means hatred, anger, intent to destroy or damage could be proven. In other words, it's awfully hard to sue a newspaper for libel. It can happen, but there has to be absolute evidence that the publisher knew and understand that the news was incorrect. Incidentally, Great Britain has much, much, much less restrictive libel laws. It's actually much easier to get a settlement if you are the one suing. And in fact, Tom Cruise, the actor, many of you know, has been a Scientologist for many, many years. And there was some kind of a publication and an outing about bad practices in the Church of Scientology. Tom Cruise actually did his lawsuit in the UK to try to protect his faith in that way because he knew that there was more of a likelihood. I don't recall what happened with that, but that's something you can look up. The next one again is it? No, it's going to be Griswold, isn't it? Yeah, Griswold. The one after this will be the one that you know. Griswold v. Connecticut. A Connecticut law, and this went back, centuries, prevented any person from using birth control, any type of drug to prevent pregnancies, birth control pills, etc., etc. The litigant in this case is Estelle Griswold. Estelle Griswold had worked for a good group called Planned Parenthood. Planned Parenthood provides services, doctor's services, informational services, mainly about women's health, about pregnancy, etc., etc. I've contributed to them for years. Good organization in my mind. Well, she is found guilty of having supplied this birth control pill to a woman. She is found guilty, takes it to the state Supreme Court. They uphold the conviction, manages to get it heard by the U.S. Supreme Court. This is tricky because it's the so-called right to privacy. Now, you can do a quick Control F on an online document of the Constitution. You're not going to find the word privacy, I don't believe. But is there something implied in individual rights? Your decision as an adult to do what you want to do with your life, with your body, in your home, not affecting other people, is that something that is collectively guaranteed by the Constitution? The ruling, 7-2. You know what? The court said we can't find it directly in the Constitution. We don't see these words, but there is an implied right to privacy. And if a man and woman in their own home decide that they want to use some kind of a drug to prevent pregnancy, That's just something you can agree with it, you can disagree with it. You can be a devout Catholic and say that birth control is wrong, and that's fine to hold that opinion, but that the state can't come in and restrict your right to do that. So again, another case for, I suppose, a more liberal interpretation of the Constitution. Individual people have rights. And then Miranda v. Arizona. Ernesto Miranda is not a real good guy. He was violent. He was known, I don't recall if he was in at one point for murder or attempted murder. He was arrested for rape and kidnapping. Honestly, I don't know about the details. I've always had a vague impression that, you know what, probably pretty valid. At least he committed numerous violent crimes. He confessed after 2 hours of police interrogation. So Ernesto Miranda is our litigant. However, he argued that he was, first of all, threatened, tortured, beaten under interrogation. More importantly, the police said, "All right, Miranda, talk." Well, no, talk now. Look, if you don't talk, you're going to make it worse on yourself. And Miranda felt like he had to start talking to the police. Now, we all know from the Fifth Amendment that you have the right not to incriminate yourself. Well, here's the question. Do we have to assume that all American citizens are deeply aware of their constitutional rights, or must the police or the arresting agency explicitly inform a defendant of his rights to remain silent and to have an attorney? Ernesto Miranda did not know that. Closer bet, and this one was probably closer because there was a lot of evidence that Ernesto Miranda was a fairly dangerous person. But the Warren court rules 5-4, that if evidence come from a suspect is invalid unless the suspect had been informed of his or her right to remain silent and to have an attorney. And again, that's something that just rolls off the tongue by now. But particularly in the day of body cameras on policemen, this is something that most police officers don't want to lose a case simply because they neglected to inform the defendant of this. Now, you might say at one point, it's like, come on, he confessed, he's clearly a pretty violent guy, but stop and think for a second why it might make sense to require this. And this is a big question. If we have a legal system, what is the goal? Is it to get every single person who is guilty of a crime and some other people that you make a mistake and as far as you know they committed a crime, but oops, I guess we got the wrong guy? Or do we want to set up a legal system in which we arrest and convict as many guilty people as we can, but we'd prefer to allow some people to go free in order to protect the bigger system? Because I think you can see, like with both this, with search and seizure. Let's say the police break into my house without a warrant and they find weapons in my house that I'm not supposed to have. Okay, well, we want those weapons taken away. We want me going to prison. But think about the power that gives the police force if they can do that without a warrant. Couldn't they just decide, we don't like this guy Ziegler for his political reasons, for his religious reasons? We just don't like him. My kid, I'm a cop and I've got a kid, and his kid, Seffi, was beating up on my kid. Well, wouldn't that allow them to come by my house anytime they wanted, and eventually they find something? Or, as happens far more than you want to think, come into my house without a warrant. Oh my goodness, we just found a bunch of cocaine. I don't have cocaine in my house. Well, I didn't have cocaine in my house until the police got there. Alabama, recent expose, there have been literally identified thousands of cases of Alabama police planting drugs, mostly on African American citizens. And this has been a recent scandal. There was also in California where, with his body camera, the policeman actually filmed himself. You can find this online, taking a packet of cocaine and putting it in the back pocket of the suspect who was arrested for some other reason. So this is the type of thing, limiting police power. Yes, we may take an Ernesto Miranda, who is honestly a pretty dangerous person to some people that he might meet, and saying we would rather this guy go free than create a police state that could damage the basic rights and liberties of literally millions of Americans. Loving versus Virginia. Sometimes you're born with the right name. And I want to point out this was not that long ago. I was 3 years old at the time. I have no memory of it. But we have a black woman whose name is Virginia Loving and a white man who lived in the state of Virginia. They fell in love. They got married. Isn't that nice? Well, it's not. The state of Virginia had a law against miscegenation, which is interracial marriage. You have violated this right. Black and white may not marry. Mildred, her name was, not Virginia. Oh, Virginia's the state. Mildred and Richard Loving were the litigants. Their argument was, look, we have our rights to due process, to equal protection regardless of our race. That's obviously a 14th Amendment case, isn't it? Well, here's the question. Does the state of Virginia have the right to ban interracial marriages? Thankfully, 14th Amendment, due process, equal protection clause, unanimously, again the Warren Court. These anti-mixed marriage laws, absolutely constitutional violations. Richard Loving, by the way, a couple years later died in a car accident. Mildred Loving died, I think you were already in high school, or at least middle school. She lived to be in her 80s or 90s and died recently, but pretty courageous now. It's certainly no state, remember, because these set precedent, so no state in the United States can refuse people the right to get married based on their race, based on their religion. Sexual preference, can a man marry a man, a woman marry a woman? We'll get to that later. That's a change we've seen in your lifetimes. And here's a feel-bad case, and one that I think will strike some people the wrong way. Clarence Brandenburg, member of the Ku Klux Klan, a leader, just, I mean, from all accounts, just a horrible, hate-filled man. Anti-black, anti-Jewish, held a rally, said these are inferior creatures, they're destroying our society, we need to be separate from them, etc. And he was eventually sentenced to prison for inciting violence, that his words could cause people to go out and attack African American, Jewish people, etc. And of course, that can happen. But here's the question. First Amendment rights. You have a right to freedom of speech. Now, it is understood that if I say, hey, go kill this individual person, attack everybody of this religion, use violence, those are considered quote unquote fighting words. Now, the question we would have is, what if Clarence Brandenburg, in the text of his speech, did not say, go hurt these people? What if he just says, I don't like them, they're inferior, they're destroying our society? Is it then his responsibility if one of the listeners were to go out and commit an act of violence? Now, I think if you were in front of me and I had a raise of hands, how many of you people in this room think that Clarence Brandenburg was a great man, a patriot, somebody you'd like to have over for dinner? There would be no hands going up. How many of you think he should have the right to speak this way? Well, the court did, unanimously. The hate speech was hateful. It was ignorant. It was stupid. But it was abstract. It was not a direct call for violence. So as much as the members of the court would find his ideas reprehensible, he had a right to speak them. Let me tell you my own version of this, and it's a case that, as much as it makes me uncomfortable, I would agree with. I grew up in a school district that was probably about half Jewish by the time I was there. I had a couple of teachers who were survivors of the Holocaust. I mean, occasionally they would show us the numbers printed on their arms. Most of the people I grew up with had family or extended family that had been wiped out directly during the Holocaust. So I had no questions about the evil of fascism, the evil of Nazi Germany, the Holocaust. Well, the Ku Klux Klan, the American Nazi Party, wanted to hold a rally, a political rally in Oak Park, Michigan, where I grew up. And quite understandably, the Jewish community and the non-Jewish community were appalled. These are horrible human beings, and how dare they, with what the Nazis did to our people, to our relatives, to some of our citizens, how dare they come to their city spewing their noxious hatred? However, did they have a First Amendment right to speak their ignorant, stupid, mean-spirited, hateful ideas? And at the age of 15, I went to, 15, 16, I went to a city council meeting where they were debating this. And being sort of a loudmouth 16-year-old, I know that shocks you, I got up and got shouted at a lot and said, look, I am appalled by the American Nazi Party. I think it is horrifying that such a thing exists. I do know my history. I know they are just trying to make people feel horrible. But my understanding of the First Amendment is we can't limit speech just because we don't like it. So I believe they should be given a right to speak and hold their political rally. And that was not a popular thing to say necessarily, but probably right. At least that's where the court has been so far. Tinker v. Des Moines, people your age. This is the heart of the Vietnam War. I mean, this is when it has become a nationwide protest movement. When the United States started getting heavily involved in Vietnam in 1964, the word was clear. Don't worry, we'll have this done in just a couple of days, couple of weeks. We're the United States. This is North Vietnam. Well, 5 years later, we're already working toward a couple million Vietnamese killed. We've already seen 20 or 30,000 Americans come back dead. It has now spread to Cambodia, and the public is, not most of it, but there is a huge, huge anti-Vietnam War protest. Two public students, school students, Mary Beth and John Tinker, wear a black armband to school as a means of protesting. Administrators said, no, this is a school. You don't have a right to make an expression like this. They were suspended. They took their case to the state Supreme Court. It was sent to the U.S. Supreme Court. Here's the question. Does the First Amendment apply to students in a public school? Now, we do agree that there are, and I think most would, age makes a difference. My 2-year-old daughter should not have the right to go out in the streets and play by herself. That would be negligence. My 20-year-old daughter can do what she wants to do. Where do we draw the line? Well, the court ruled 7-2 that the school district had violated their rights. The school said this will cause such disruption that we can't run a regular school day. We can't guarantee people's safety. A couple of the Supreme Court justices bought that, but the majority said the amount of risk to the school and the functioning is minimal. The First Amendment rights apply more so. Furman v. Georgia. This is an Eighth Amendment case. William Furman was sentenced to death row for murder in Georgia. I don't know much about William Furman, don't know how clear the case was, etc. He was arguing that this is, yes, cruel and unusual punishment. However, the lawyers argued a second problem, more based on the 14th Amendment. Said, Mr. Furman is African American, and we're looking at the evidence, and in Georgia, in other states, we're finding that when African Americans are found guilty of capital cases, one that could result in a death penalty, they're far more likely to actually be sentenced to death. So we think that there's a problem, not just with, hey, this is terrible to execute somebody, but we think that people are not getting equal protection and due process under the law based on race. 5-4 decision. Struck down state capital punishment laws, not just in Georgia, but across the entire country. They did rule that if it's done in a relatively quick, painless, humane way, it doesn't violate the Eighth Amendment, capital punishment, but that it did violate the 14th Amendment, as enough evidence was placed that blacks and poor people were much more likely to be sentenced to death and executed. Every state that wanted to return to having the death penalty, I think about 30 do today, 20 don't, roughly that, they had to rewrite their laws to try to cover grounds in this case so that there was no built-in discrimination against poor or black candidates. I think there's a case about 4 years later, Gregg v. Georgia, that allowed the death penalty to be implemented again. However, poorer people and people darker of color are still far more likely to be sentenced to death. It's something I think that we're overlooking still. But nonetheless, that's where the law stands. Okay, here comes a naughty one. Marvin Miller was convicted of the sale and distribution of obscene materials. Dirty books, naughty pictures, videos. Don't know if they had videos in those days, but maybe films that were produced. You'd better believe it. Now, obviously, you would have the state of California saying, I'm sorry, we don't allow obscene materials to be printed and distributed. What, will someone think of the children? What happens if children end up seeing some of this? Does it end up destroying the moral fiber of a community, etc.? What do you suppose that Marvin Miller and his lawyers argued? First Amendment. Wait a minute. You call it obscene. I call it art. I call it personal expression. Now you may say, oh, that's ridiculous. Well, what about Michelangelo's David? What about the giant nude statue? Is that obscene? Well, most people would say, no, that's a beautiful work of art. What about one of Mr. Miller's films? That's obscene. No, it's a work of art, would be his argument. Two very, very, very funny stories come from this. Bob Woodward, who, well, first of all, helped to break the Watergate case. You might recall Woodward and Bernstein, both of these journalists are still alive and active. Also wrote a book called The Brethren, Stories About the Supreme Court. And true stories. One justice was asked, what is your definition of obscenity? And his response was, well, I don't know how to define obscenity, but I know it when I see it. Now, this is true. I'm not making this up. I should probably be fired if I'm making this up, but I'm not making it up. One of the things that the Supreme Court justices had to do, these 9 older men, was sit in a dark room and watch pornographic films. After all, they have to rule on whether these are obscene or not. In the room, of course, are younger pages, assistants, young men mostly. I don't know if there are women at this point. Perhaps there were, but in their 20s or 30s, fresh out of college, they do a lot of the grunt work, etc. So as the Supreme Court justices and the younger staffers are sitting there, something would appear on this giant screen in front of them, and people would start shouting, I see it, suggesting that they're seeing obscenity. The second part, an older justice whose name was Potter Stewart. Potter Stewart, by this point, was legally blind. So an intern, an aide, was assigned to sit next to him and whisper into his ear, hey, no, let him go. Out, Emma. Emma, that's not nice. Do not do that again. No, out. I'm sorry about that. My friend's daughter just grabbed my cat by the paw and tried to rip it off, so made it very clear that that's not okay. Anyway, sorry about that. I would have pressed pause if I wasn't reacting in such horror. So, I wonder what the hell she was thinking. Anyway, Potter Stewart was legally deaf, or legally blind, excuse me. So the young intern had to sit next to him and whisper in his ear what was going on the screen. And one exchange went like this. Potter Stewart sitting blindly, and the intern saying, Mr. Justice, at this point, the young woman is, and the young man is, and Stewart says, now, what was that? Well, Mr. Chief Justice, the woman is taking her, and Potter Stewart shakes his head, smiles, and says, outstanding. And that's actually a true story. Again, sorry for the interruption there. 5-4 decision. The court rules, states can limit obscene material. They can decide that something, I'm sorry, this absolutely is not acceptable in this area, in this state and city. There is some room to do this. However, outright bans of anything that might be considered to be obscene, you just can't do that. So it needs to be more specific. If we ever get back, maybe I'll send you a yeah, I will. Remind me with this. I will send you Steven Pinker's statement about what was considered legal and not legal in terms of speech and etc. But this gets tricky. Bottom line, yes, obscenity can be a reason for banning some materials, but just simply saying anything obscene is not enough. Notice this was obviously hotly contested. It's a 5-4. And we have one final one. By this point, Earl Warren has died. This is the Burger Court, but that's not important for you to know. But it's a major case that you will hear a lot about, especially if you're in the United States next year. Roe v. Wade. Norma McCorvey was not able to get an abortion. She had gotten pregnant at 17, I think something like this, and she was wanting to get an abortion. She lived in the state of Texas. She did not, because it was a privacy case. It's actually Jane Roe. That's just an anonymous, random name, Roe v. Wade. Wade is an official of the state of Texas. So here's the question. Now, Norma McCorvey has to give birth. Court decisions often take a couple of years to do. But here's a question. Are state laws that ban abortion constitutional? And that's an interesting question. This comes back to privacy, doesn't it? The question would be, if I, as a woman, choose to terminate a pregnancy, is this a decision that I make with my body, myself, or does the state have a right to say this is immoral behavior, or there is a heartbeat of a fetus, etc., etc.? Well, controversial decision, 7-2, argued that the woman's right to privacy, and they used the Due Process Clause, the 14th Amendment, stated or prevented the state from putting most restrictions on the right to abortion. And that's at least in the first 2 trimesters, first 6 months or so. Understand that if a fetus is born prematurely at 4 months, 5 months, simply is not going to be able to survive. 6-month period is fairly difficult. 7-month, there could be a lot of complications and problems, but it's often thought that starting in about 6-7 months, you have somebody that would survive as a human being. And unless there is a clear, compelling case in most states in which, look, there are major complications, we think that the mother may not survive, there are usually fairly strong restrictions beyond about the first 6 months. By the way, watch this. In very recent months, 4 or 5 states, mainly in the U.S. South, more conservative ones, have put what they called heartbeat bills. As soon as a heartbeat can be detected, and I think this is after about a month or so, no abortion will be allowed. Very, very recently, federal courts had overturned those bans, etc. Certainly, looking at the Supreme Court, the possibility that they may review Roe v. Wade, probably there are 5 votes that would make some huge changes to Roe v. Wade. Major political ball of wax, to be sure. Probably the reason why anybody who is an abortion supporter who said, oh, I just can't vote for Hillary Clinton because I don't really like her, probably made a pretty bad mistake, because Hillary Clinton would not have appointed 2 ultra conservative Supreme Court justices who are personally very strongly opposed to abortion. Will this turn into an actual vote in the Supreme Court and an overturning of Roe v. Wade? We don't know it. But if you're living in the United States next year and you just open the occasional newspaper, you're going to see Roe v. Wade overturning it, Roe v. Wade protecting it. All right, so there we are. That went a little longer than expected, especially when shouting at my kid's friend. But God, it was horrible. She just grabbed the cat by the paw and started dragging him across the bed. And I think you heard him howling. And I don't know what the hell she was thinking. But anyway, when I yell at a small child, they normally think, ooh, he's scary. And they don't do it again. So, all right. One more coming. Promise won't be as long as this one. Yeah, be a little bit shorter the next one. So, and then we're done with this unit and done with the PowerPoint lectures. See ya.